Now, welcome back. We want to talk about what the Court of Appeal decided last week in a matter that had been appealed against the Court of Appeal, and they found that DCJ Mwilu made a mistake by failing to give the reasons why she was the one impaneling a bench to determine some 3 matters before the High Court. And they said that the Chief Justice, in this case Martha Koome, should forthwith go ahead and within 14 days empanel a bench of 3 to hear this matter. The court also said that it is up to the Chief Justice to decide whether Justices Ogola, Mugambi and Murima will still be the same ones to hear that matter. I'll be hearing from the panelists here in studio. I want to begin with you, Senator Eddie Oketch. If you think this has any implication, because I see some developments of different people saying things, including a headline that stated that Deputy President Rigathi Gachagua is in office illegitimately.
First of all, I think it would be unfair if I have one bite on the cherry of IBC and all my panelists have two bites.
Go ahead.
But it's okay because we have to transition. I understand that. I've been in this debate for quite a while. But just allow me 30 seconds to say that I would wish my fellow panelists to question the character and the merit of these individuals. Because if the question of the process of adding another person is justified by law, that is, should the report come and also should it be put in court, you see, there is only one person on that additional list that actually made it to this list. So there could have been some questions. Maybe it's an issue of regional balance, or maybe youth balance, or any demographics. I don't want to justify that until it is subjected to law, but I wanted us to question the character and the merit of these individuals, so that they can give the country confidence in the election process. Okay. But that is a discussion that is now seems to be been transitioned. On this other issue of Rigathi Gachagua, I think that I would want to wish Gachagua and the likes who want to talk about this to move on. Because the substantive element in this discussion is that there is independence between legislature and the judiciary. And the legislature overwhelmingly impeached Gachagua. And I can assure you that even if he was to come back today in the same 2 houses, he will still be overwhelmingly be impeached. So the legal question, for me, it can continue, and I respect the judicial process that are continuing, but I don't think it has the impact that is desirable in the eyes of factions that are with Gachagua with regards to the substantive issue, which is turning or changing the fate of the impeachment under Article 144.
How important is the process?
The process is, I'm saying the process is very important, and I'm saying that the process that had gone through the legislature was a lean, clean, and overwhelming. That's all that that is important.
That's interesting, because when you speak about even on the question of IBC, you're talking about it is up to the country and, of course, Parliament to look at the qualification of those.
Yes.
But you also know that there's a question of procedure, which is very critical. On the question of impeachment, you're saying that the House made its decision, which it did. Yes. That's fine.
Yes.
But, of course, after that, there was an appeal at the High Court. And the reason why Deputy President Professor Rigathi Gachagua was sworn in on the 1st of November 2024 is because the 3-judge bench cleared the path and said that there is no situation in the Constitution that a country should be without a deputy president for a prolonged period of time. If that bench that was constituted outside what the Constitution would say, you don't find that important?
I think is important in the judicial process, because what it could mean, for instance, because I like what becomes the way forward. For instance, if it is annulled that process in the judiciary was wrong, then I think that it goes without saying that the process has to be done through the Chief Justice herself, right? And if it is done, I cannot preempt the outcome of that process.
Okay.
All I can talk to authoritatively is the process that was concluded in the National Assembly and in the Senate.
That's fine. What is it, Mheshimiwa Maina?
You know, it's very unfortunate that a young leader
like Eddie Okech, does not care about the process. I wonder whether he cared about the process in 2022 when his political leader, Raila Amolo Odinga, was disputing the election results. And
allow her.
It is quite, you know, because let me just give context to this, Sam. The Senate did not even conclude the hearings in regard to the impeachment of His Excellency Rigathi Gachagua. They could not find time to allow him to recuperate and appear before Senate to be heard or to respond to the allegations that were tabled before Senate. And you see, Eddie Okech tells you that even if it is brought right now, the decision would be the same. Because there seems to be, you know, a lack of need to evaluate and question the grounds. You know, it is just about a means to an end. It is about the result for the two houses. And the challenge before the Court of Appeal, or the decision that was challenged, was in regard to empanelment of the bench by the DCJ. And Article 165 is very clear that the person who has the mandate to empanel a bench is the Chief Justice. In her absence, perhaps if she's incapacitated, it has to be formally communicated. There was a decision in regard to the Lena Coachella case. But then the matters that were before the High Court were in regard to orders that had been issued by a sister court, the same level High Court, in regard to the swearing in of the now Deputy President, a very weighty matter. But then the same bench sat and, of course, decided that the DCJ had the powers to empanel, despite lack of evidence that there was a formal communication, a formal delegation of a power that has been vested solely on the Chief Justice.
So Mheshimiwa Maina, what is the consequence of this?
The consequence of it is that we revert to status quo ante. Because,
which is?
Yes.
Which is?
I'm just coming to explain that here. I know you're not, I know you're not a lawyer, Sam. Which is that if the bench sitting to lift the orders was improperly constituted, then any decision in regard to those matters would be invalid ab initio, would be null and void. And I know that my colleague here perhaps might make a different argument depending on, you know, the side. Because lawyers are lawyers at the end of the day. But the fact of the matter is, Sam, if a bench that is sitting makes decisions and then another decision is made, even from a layman's perspective, a decision is made that that bench was improperly constituted, it should not have undertaken that mandate.
So are you saying, because
the decisions,
that bench led to the swearing in of Deputy President Kithure Kindiki, are you saying now DP Kindiki should not be in office, or are you saying?
What I'm saying is that that interpretation is correct. And even from a layman's perspective, you do not need an IQ of above 50 to see that if a bench is improperly constituted, makes decisions, and then another court of a higher ranking says that the bench should not have been deciding on such matters, then of course any decision they undertook would be invalid. Okay.
Wakili Ogolla, what do you think?
Sam, first of all, I hope that we have all read the judgment. Because for me, I've read it, and I don't see what the judgment says coming out. Now, the pressing question flowing from the Court of Appeal judgment is whether, by dint of that judgment, Mr. Gachagua may be deemed to be back in office. The short, simple, and straightforward answer is a resounding no.
That's what I said.
Sam. Let us not conflate what the court said. The appeal addressed the question of legality and propriety of the High Court the High Court ruling that declined or dismissed Mr. Gachagua's contention that that bench was not properly constituted. The justification for that contention, according to Mr. Gachagua, was that the Deputy Chief Justice, Sam, did not enjoy constitutional powers to empanel such benches.
Right.
Permit me now to settle this debate by reading verbatim what the Court of Appeal said at paragraph 144 and 146. The Court of Appeal held that empanelment of benches is an administrative function and can be performed by the DCJ. Remember, Mr. Gachagua was attacking the composition of the bench because it was appointed by DCJ on grounds that DCJ does not enjoy that mandate.
Right.
At paragraph 158 of that judgment, this is what the court said verbatim. We do not doubt the bona fides of the Deputy Chief Justice in constituting benches. But we have discussed why it is critical to communicate to the public why the Chief Justice did not exercise that administrative function. Now, the Court of Appeal agrees with the High Court that the Deputy Chief Justice can appoint benches. The Court of Appeal nonetheless disagrees with the High Court. Does not mean that it agrees with Mr. Gachagua.
May.
It disagrees with the High Court. Mheshimiwa, unless you are reading, disagrees with the High Court, saying that instances where the DCJ may appoint the bench, those instances must be communicated. And then proceeded the consequences, because you asked about the consequences, Sams. There are only 3 consequences, and they are in the judgment. The first consequence is that bench then needs to be reappointed by the CJ, the bench. Because remember, Gachagua had attacked its impartiality. The court found that there was no evidence that the bench was not impartial.
Right.
So the same bench must be reappointed by the CJ. The second implication is that the Court of Appeal...
You said must.
Yes, the file to be referred to the Chief Justice to reappoint the bench.
That's not what the judgment says. It says it is up to the CJ to decide whether to empanel the same.
Actually, the Constitution is very clear.
Just hold on.
Yeah.
I mean, this you're splitting hairs.
No, you're not splitting
hairs. I'm telling you. Just hold on. Just hold on.
Yeah.
The Court of Appeal directed that this bench then be reappointed by the Chief Justice. Number 2, the Court of Appeal says it is better that the Chief Justice provides guidelines on how courts can sit on Saturdays or weekends or public holidays. Number 3, that there should be guidelines, if you read the judgment in its totality, that circumscribes instances when the DCJ may appoint the bench to avoid giving reasons post facto. You get? Now, those who understand how litigation works, it is not the business of the court to repair the pleadings of parties before it.
Sure.
The court cannot grant orders or prayers that were not requested. The Court of Appeal reproduced the application that Mr. Gachagua sought to be upheld by the High Court, which was declined, and therefore they wanted the Court of Appeal to allow those orders. Those orders sought at the Court of Appeal did not include a review of the ruling that set aside Kerugoya High Court orders, which then paved the way for swearing in. The way forward, if they wanted to, then maybe they could file an application before the new bench. The CJ may appoint this bench or may reconstitute if he thinks so. But the options that exist is not to jump the queue and say, now Mr. Gachagua is reappointed. You could go back to the High Court, file an application for review of that ruling, citing this judgment. Then the High Court will confront that question head on by saying, look, the question whether this ruling, the question of setting aside the orders from Kerugoya in petition number 13 of 2024 was never appealed. Remember, there's a specific ruling. That ruling was never appealed.
Okay. Well, okay, I just want to understand, and I'll get you, Hashi. If the CJ reappoints this same bench, or rather, appoints this same bench, or appoints a different bench, so what then? What matter is before them?
If the CJ reappoints this bench, they already, and I'm in that matter because we're already at the stage of filing submissions. Remember, this was an appeal on empanelment of the bench, not an appeal on the process on impeachment. The process leading to the impeachment is substantially pending at the High Court, and the High Court has given directions on exchange of submissions in respect of that petition. So if the Chief Justice were to reappoint this bench, which is basically to revalidate the decision or ratify the decision by the DCJ to appoint it, what would happen procedurally is that that bench would then continue with the directions it had given on disposal of the main appeal. So we'd be expecting to go back to the High Court to argue Mr. Gachagua's appeal or petition on the merit.
So, yes. It would be a continuation.
It's a continuation.
What if it's a different bench?
Whether it's a different bench or the same bench, the continuation of the substantive question persists, because the substantive question is, was the law, substantive and procedural law, complied with in the process leading up to the impeachment?
Yeah. Right.
That question is still pending.
Okay, all right. Hashim, what do you make of this?
So the politics of it is really grave. I think on the side of Mr. Gachagua and his team, the end game for the judicial process is to clear his name as far as what was done to him by the National Assembly, so that his legitimacy on the ground as running for office can be returned. And that's another look on it. It's a totally different subject. But the critical thing about this, and I'm with the lawyer on this one, is that the National Assembly's decisions trump everybody. It's the most important political institution we have in this country. Of course, the president, the executive, is running roughshod over our National Assembly. But if the National Assembly really read its law, it understands that it has a lot of power. And the question before us now is the removal of the deputy president. Of course, the judiciary has every right, and the plaintiff has every right to go to court and say, was it right? Was it done properly? Was the process safe? But consider for a moment that they say it was all done very well. You know, let's just go back to the National Assembly, and the Assembly would just throw him out again. So I think that for the purposes of the Kenyan public, we should go through this judicial process. The Deputy President has a right to get his day in court, and it's now clear that it's the Chief Justice who has to constitute this thing. It's clear. And I think after that, then the court will make its judgment, and we will live by the judgments of the judiciary. Okay.
Sam, just a rejoinder. Those who know how to interpret judgments will tell you that we would revert to status quo ante. That is all.
Okay.
Sam, because I was accused here, I was accused of not respecting process. I think that I want to affirm this, that the process that was followed by the National Assembly and the Senate, and actually in this impeachment, I think that it's the Senate that is superior to the National Assembly, because National Assembly is actually just an accuser, right? It accuses the Deputy President in that process. That process was done to conclusion under Article 150 in the removal. You are deferred, if you do that Article 152, you are deferred to the tenets of Article 144 and 145 on how to impeach the president. And that process, that's what I was meaning, that process was concluded. Okay. So unless it's substantive question of that process, then I said move on.
All right.
Yes.
All right. So as we move on, the